Mr. Epstein, how long have you been sexually attracted to underage minor females?
Objection, harassing, argumentative. Are you kidding?
Now, convicted sex offender Jeffrey Epstein was no stranger to depositions. The accused trafficker was questioned on the record in relation to civil lawsuits that were filed against him by women who claimed they were just teenagers when they were pulled into Epstein's alleged despicable web. Well, we found one of those depositions in the Epstein files release, and it gives you an idea of how Epstein himself, his own attorneys, and opposing counsel approached these cases. And let me tell you, it is very illuminating. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. All right, before we go into this, here's the truth. Life insurance, I know, it's not fun to think about, but this year you have to take care of the important stuff, and nothing is more important than family. And that means having a policy to protect your family so you can have peace of mind. And it doesn't have to be complicated. It doesn't have to be time-consuming. Fabric by Gerber Life is term life insurance you could get done today. It's made for busy parents like you, online, on your schedule, right from your couch. You could be covered in 10 minutes with no health exam required. If you've got kids, especially if you're young and healthy, the time to lock in low rates is now. Fabric offers policies that are high quality and flexible to fit your family's budget. Plus, there's no risk with a 30-day money-back guarantee. Join thousands of parents who trust Fabric to protect their family. Apply today in minutes at meetfabric.com/sidebar, meetfabric.com/sidebar. So far in our coverage of the Epstein files release, we have gone through thousands and thousands of documents, photos, videos, and I will tell you, it's pretty much like we've barely scratched the surface when you think about millions and millions of pages. But we are learning new details, and we are getting the chance to view more evidence against Jeffrey Epstein every day, or at least more what was going on in his life. Now, in a previous sidebar, we looked at some of the creepiest, cringiest videos of Epstein. For example, this selfie video of him making weird and unsettling faces into the camera. You have another showing him standing up on a countertop in a large kitchen, then getting down and literally chasing a female around the room. There's also footage of him dancing with someone in what appears to be a hallway. But I will tell you, also in these files, released under the Epstein Files Transparency Act, are depositions related to civil lawsuits that were filed against Epstein and his on-again, off-again associate, girlfriend, alleged Madam Ghislaine Maxwell, who, by the way, was convicted and sentenced to 20 years in prison on sex trafficking charges. Now, what I want to do today is I want to dig into one of those video depositions that was taken in February of 2010. This is part of a lawsuit that was filed against Epstein by an alleged victim. She's referred to as LM. She sued Epstein in Palm Beach County, Florida District Court, claiming that essentially she was lured to his home and forced to perform sex acts, eventually becoming what she would call a sex slave. Now, Epstein actually went on the offensive. He would actually end up suing the lawyers in this case, claiming basically that they had tricked people into filing civil claims against him, thus defrauding him and making Epstein look bad. Court paperwork called it a Ponzi scheme, and his disdain for this law firm will come up several times in his responses. You're going to see it. But I do want to play you some really interesting clips from the deposition, because the camera focuses on Epstein, but off camera, you're going to hear from LM's attorney, Brad Edwards, and Epstein's attorney, Michael Pike, okay? Now, Brad Edwards had worked for a law firm called Rothstein, Rosenfeld, and Adler. Apparently, the top partners at that law firm would eventually be charged and later convicted of financial crimes. We're talking things like racketeering conspiracy, wire fraud, money laundering. And Edwards points out at times during the deposition, essentially, look, I'm there representing LM. The accusations against this former firm are irrelevant and essentially a distraction that Epstein's making. Now, to set the timeline for you, because I think that's important, this deposition, again, is in 2010. This is after Epstein has already been convicted. Remember, he pled guilty to those Florida state sex crimes charges, solicitation of prostitution with a minor. He spent some time in jail as part of that sweetheart deal. He was able to avoid federal charges. So now he's facing this civil litigation. And you can tell immediately, Edwards is not going to get much out of Epstein.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Can you give us your name?
Jeffrey Epstein.
Mr. Epstein, you made a comment when you came in the room that you were appreciative of me being respectful to your housekeeper yesterday, and I intend for that to be the same with you today. I want to start by asking you, at this point, We've gone through a lot of discovery in this case. There aren't many disputed facts as to what actually happened at your house. And generally, I think you would agree that you devised a way for young females to come to your house and engage in varying degrees of sexual activity. Some of the girls as young as 12, some of them as old as 17 or so, most in between. But as of yet, you haven't provided an explanation. So I want to provide you an opportunity to tell the jury at this time why you did it.
I'm going to object to confusing, compound, and irrelevant as wording.
You know, I'd like to answer that question, frankly. However, at this time, my attorneys have told me that I can't, and I must invoke my 5th, 6th, and 14th Amendment rights, or I risk losing their counsel. Accordingly, I therefore assert those rights. Sorry.
And in addition to that, I'm going to move to strike counsel's statement as narrative as well.
I understand. We wanted to provide him the opportunity if today was going to be the day.
Same thing, move to strike narrative.
Mr. Epstein, how long have you been sexually attracted to underage minor females?
Objection, harassing, argumentative.
Are you kidding?
No, I mean, I don't feel like I'm divulging any secrets here, right?
Move to strike.
No, that's the question.
I'd like to answer that question as well. I'll get all your other questions today. However, I have to follow my attorney's advice. They have told me that I must invoke my 5th, 6th, and 14th Amendment right to not answer those questions today or any questions relevant to this lawsuit. So accordingly, I'm going to assert those rights, and under the Constitution, is guaranteed by the 5th, 6th, and 14th Amendment.
Okay. Would you consider yourself addicted to sex with minor females?
Same objections.
You know, Mr. Edwards, I want to be very respectful. And as the current U.S. Attorney has described your law firm as a criminal enterprise and part of one of the largest frauds in Florida's history, it's been reported that your firm has fabricated multiple cases against me in order to fleece unsuspecting investors out of millions and millions of dollars. So unfortunately, at this time, though I'd like to answer that question, on advice of counsel, I'm going to have to refrain and assert my 5th, 6th, and 14th Amendment right.
Can you then provide an explanation for what relevance that soliloquy of yours has to whether or not you engaged in sex acts with she was a minor?
Objection. No, he cannot. Argumentative, compound, harassing.
Mr. Pike, with all due respect, it wasn't my idea for him to give this speech about a former RRA law firm. I'm just asking him, elaborate on that.
Counsel, I'm working with your follow-up question. So I'm objecting, and I'm objecting to form and stating the reasons on the record as to why the form is required to be objected to based upon your question.
Will he elaborate on the relevance of that soliloquy to his touching when she was 13, 14, and 15 years old in a sexual manner?
I'm going to object again, argumentative, compound, harassing, and irrelevant as worded.
You can answer.
I'd like to answer. However, I'm going to have to assert my 5th Amendment, 6th Amendment, and 14th Amendment right as advised by my counsel. Otherwise, I risk losing their advice.
Mr. Epstein, have you ever been diagnosed with a sex addiction to minors by a psychologist or other medical professional?
I intend to respond to all your questions at some relevant time. However, today, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit, and I must accept their advice or risk losing my 6th Amendment right to effective representation. Accordingly, I assert my 5th, 6th, and 14th Amendment rights to the United States Constitution.
In addition to that, Mr. Edwards, as the court has ruled in several matters, Mr. Epstein's medical history is not relevant at this time, nor has he placed same at issue in this case.
Understood. Mr. Epstein, Were you sexually abused as a minor?
Again?
Were you sexually abused as a minor?
You know, I'd like to respond to all your, if any, questions seem to be relevant, but I would like to respond to any relevant question at this time. However, my attorneys have counseled me that I cannot provide answers to the questions relevant to this lawsuit today. I must accept their advice or risk losing my Sixth Amendment right to effective representation. Accordingly, then, I assert my Fifth, Sixth, and 14th Amendment right to the United States Constitution.
Isn't it true that you have engaged in some sexual interaction with hundreds of underage minor females in the last 10 years of your life? Is that true?
Objection, relevance.
Mr. Edwards, the current U.S. Attorney has described your law firm as a criminal enterprise and part of the largest fraud in Florida's history. It has been reported that your firm fabricated multiple cases, many multiple cases against me in order to fleece unsuspecting investors out of millions and millions of dollars. Unfortunately, at this time, in response to your question, my attorneys advised me that I must assert my Sixth Amendment, Fifth Amendment, and 14th Amendment right. Though I believe you know that I would really like to answer your questions today, but at this moment I must assert those rights or risk having my attorneys resign.
You're invoking your Fifth Amendment rights to each of these questions because you know that your answers will incriminate you and you feel that it will result in you being prosecuted for these crimes. Isn't that right?
Objection, argumentative, harassing, and calls for a legal conclusion.
Yeah.
No, in fact, the Supreme Court recently said that the Fifth Amendment right is there to protect the innocent. So that's the way I'd like to answer that.
Are you actually telling the jury that you didn't commit the crimes that have been alleged against you by the various females that were underage when you engaged in sex with them? Are you telling the jury that right now?
Objection, argumentative, harassing.
I would like to respond to that question, as you know. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit, and I must accept their advice or risk losing my Sixth Amendment right to effective representation. Accordingly, I assert my Fifth, Sixth, and 14th Amendment right under the United States Constitution.
Mr. Epstein, you understand that this is the video that will be played to the jury in trial against you, and wants answers. These juries are going to, the jury is going to want answers. So I know that you're telling us that you're going to respond at some time in the future, but the time is now. Would you like this opportunity to explain why you engaged in sexual activity with beginning when she was 13 years old and you were 50 years old?
I'm going to object once again. We're getting way too argumentative with the questioning. The questioning is compound, it's speculative, and it's also harassing. Whether or not this deposition video thereof is played in front of a jury is a question of fact, and it will be determined by a judge pursuant to a motion in limiting various portions thereof may or may not be played. So, having placed those objections on the record, I'm going to instruct Mr. Epstein not to answer that question.
Mr. Pike, I don't know if you watched the 13 hours of harassing questions to Ms. that she sometimes invoked her Fifth Amendment rights, and I understand the adverse inference that will be given. And she was made to answer these questions, and these exact same questions were asked of her. In fact, I'm using the phraseology from Mr. Loutier. I'm not trying to harass him. I'm simply asking him to explain to the jury, if you're saying that it didn't happen, say it didn't happen. If you're saying it did happen, explain to the jury why you did it. That's all we want to hear. I'm being respectful about this.
In an effort to keep a clean record and be respectful to the co-reporter, and rather than have a diatribe back and forth between you and myself, I'm going to move to strike your last statement as irrelevant. Let's move on.
Mr. Epstein, is it true you were born January 20th, 1953?
Yes.
Where?
New York.
Where in New York?
Brooklyn.
Did Did you go to high school there?
Yes, sir.
Where?
Lafayette High School.
After high school, did you attend college?
Yes, sir.
And where was that?
In New York.
What college did you attend?
Cooper Union.
I'm sorry.
Cooper Union.
And did you get a degree from Cooper Union?
No, sir.
How many years were you in college?
I believe 2.
What did you study?
Physics.
And why did you leave college early?
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to questions that may be relevant to this lawsuit. So accordingly, I assert my constitutional rights as guaranteed by the 5th, 6th, and 14th Amendment.
By you invoking your Fifth Amendment rights as to why you left college, is it safe then to presume that that answer you believe would incriminate you in some way?
Okay, I'm going to move to strike speculative, argumentative, harassing, calls for a legal conclusion. And I know exactly what you're trying to do here, Mr. Edwards, is lace the record with questions that would ultimately give you an adverse inference at any potential trial of this matter. So having put that on the record, I'm going to instruct him not to answer that question based upon his 5th, 6th, and 14th Amendment rights to the United States Constitution.
With all due respect, you cannot invoke his Fifth Amendment rights. Your attorneys instructed me in that fashion.
He can.
And Tatum Miller had to do it herself. So I'd like to hear it from Mr. Epstein. Can we assume that by you invoking your Fifth Amendment rights as to why you left college early, that that answer you feel would incriminate you?
Once again, move to strike for the same reasons.
Okay, quick refresher for the 5th, 6th, and 14th Amendments, all right? By the way, it's any person's right to invoke these. It doesn't necessarily mean somebody is guilty of something, but let's put it into context here. So, Fifth Amendment, right against self-incrimination. You don't have to answer questions where you would inadvertently admit to a crime or being connected to a crime, right? Makes sense. Sixth Amendment, whole cluster of rights there that includes the right to be told what the charges are or the accusations are, the right to confront or question the witnesses against you or accusing you. You get your own witnesses, you have assistance of counsel, so that's big here. Again, just making sure that nothing he says would jeopardize any of that, but also he has a right to follow his counsel's advice. Now, the 14th Amendment, one of the things that it does here, it's about due process, right? Can't be denied life, liberty, property without due process, meaning certain procedural steps need to be taken, like a hearing. The government has to tell you what's happening. You have an opportunity to respond. And also the government, by the way, has to have a compelling reason to deny you of life, liberty, or property. But also, the 14th Amendment applies the 5th Amendment rights, or what I just talked about, to the states. Little constitutional law lesson, but there you go. Okay. Now, Epstein does answer some really basic questions about where he was born, Brooklyn, where he went to high school, Lafayette, where he went to college, Cooper Union. By the way, he confirmed he dropped out of college after only a couple of years. But from there, Epstein went back to invoking his rights to nearly every single question, including these.
After college, where were you employed? Well, isn't it true that you were a teacher at the Dalton School in New York after college? Mr. Epstein, did you have sex with any underage students while teaching at the Dalton School?
Could you repeat that?
Yes. Did you have sex with any underage students while teaching at the Dalton School?
Now, he was also asked if he worked at Bear Stearns, if he knew Leslie Wexner, right, Victoria's Secret, if he worked for him. Same responses. How about these? How did you meet Ghislaine Maxwell? Do you have an apartment in Manhattan? Do you own an island in the U.S. Virgin Islands? Do you own a home in New Mexico? Now, Epstein varied his answers slightly, but he always comes back to asserting his rights, or saying that the law firm that I mentioned before, that, hey, they have been determined to be corrupt. But Edwards, he just pressed on.
Is it true that you have had underage females at each of those homes for with you and Ghislaine Maxwell?
Form, argumentative, speculation, and harassing.
Well, I would like to answer that question. I really would. However, as your firm has been described by the U.S. Attorney as a criminal enterprise, whose principal purpose was racketeering conspiracy to generate money for the firm and its co-conspirators through the operation and enterprise, and through various activities including mail fraud, wire fraud, and money laundering, and fabricating multiple sex cases against me and others. Though I'd like to answer your question today, Mr. Edwards, my counsel has advised me I must take the 5th, 6th, and 14th Amendment right as provided by the U.S. Constitution.
Did your sexual obsession with underage minor females grow at some point in time to allow you access to these underage minors every single day for sex?
Overbroad, speculation, argumentative, compound, harassing, and confusing. Confusing as worded. You want to break it down, Mr. Edwards?
Isn't it true that for the past 10 years, you have found a way to engage in sexual conduct with underage minors on an everyday basis?
Speculation, argumentative.
You would agree that you interacted with every day in a sexual way when she was 15 years old?
You know, again, Mr. Edwards, I'd like to answer all your questions here today.
I'm reading from the complaint filed by against you. Isn't it true, sir, that a friend of yours sent you 3 12-year-old females for you to sexually abuse on one of your birthdays?
Form argumentative, harassing, and irrelevant to this lawsuit.
But you're saying it's part of the lawsuit?
Yeah, I'll read it directly. On one of defendant Epstein's birthdays, a friend of defendant Epstein sent him 3 12-year-old girls from France who spoke no English for defendant to sexually exploit and abuse. After doing so, they were sent back to France the next day. Isn't that true?
Once again, I'm going to move to strike.
Is it true that you forced as a 15-year-old girl to have sex with numerous friends of yours?
Are you kidding?
Reading from her lawsuit.
Oh, you're reading from the lawsuit. Oh, sorry, Mr. Edwards. I'm going to have to, though I'd like to answer that question as well, as I answered most of your other questions here today, I would like to respond. My attorneys, however, have advised me I have to assert my 5th Amendment, 6th Amendment, and 14th Amendment rights under the U.S. Constitution.
Now, at points, when Edwards brought up Epstein's seemingly known associates like French model scout Jean-Luc Brunel, who, by the way, he died in a jail cell in 2022 when he was being investigated for rape, Epstein acted like, or seemingly acted like, he didn't even know or remember who they were.
You know a man named Jean-Luc Brunel?
Can you spell it?
He was at your house last week. Does that remind you?
Form, move to strike, speculation, argumentative, harassing. Is there a question on the table, Mr.
Yes, do you know him?
Could you spell his name for me, please?
I don't need to spell his name. You know who I'm talking about, Mr. Brunel.
I'm sorry, could you... Mr. what?
B-R-U-N-E-L.
I see. I would like to answer that question as well, but my attorneys have counseled me to that today. I'm going to have to assert my 6th Amendment rights, my 5th Amendment rights, and my 14th Amendment rights under the U.S. Constitution, or risk losing my right to effective representation.
What's the purpose for you asking me to spell his name? Are you acting like you don't know him?
Form, move to strike, argumentative, and irrelevant as worded. Mr. Edwards, you know that there are various standing orders, if not in this case, in various other cases, that specifically describe the protections of the 5th Amendment. Federal courts have ordered that certain questions that you are asking shall not be answered, or Mr. Epstein would risk losing his 5th Amendment right.
No, I understand that.
Under the United
States. People's names.
Wait a second. Under the United States Constitution. A lot of these questions here today that you're asking have already been ruled on by various courts that the 5th Amendment protects any response thereto. So I would like it, I'm giving you some leeway here with regard to these argumentative questions. We've already, and I'm not obviously testifying for the witness, but we've already handled a lot of these issues in court, and we've already adjourned one deposition for being argumentative, and I think you understand what the court said there. So, having said that, and I understand that you have a job to do, but having said that, I would like to caution you professionally that if you continue with the argumentative questions, I am going to have to terminate this deposition, and then we'll just
Do what you have to do, Mr. Pike. I completely understand.
Okay. We're here today.
Mr. Brunel is
I'm sorry, just go ahead. We're here, I want the court to know that we're here today to allow you to ask your questions, but the harassing and argumentative tone is not going to be tolerated. So
There's
just
a
go ahead and
video.
proceed.
There's a video. We can show the court the tone. It's obviously not harassing. So,
That's fine.
Mr. Brunel is a longtime friend of yours, right?
I intend to respond to all relevant questions to this lawsuit.
And Edwards continued to try to pin Epstein down on specific details, but the deposition has been underway for hours now, and you can tell things are getting a little tense.
With respect to underage females, isn't it true that you have made the statement, in quotes, the younger the better? Isn't it true when underage females were brought to you, you would engage in sex with them and pay them?
Form, argumentative, harassing.
Are you shaking your head to say no?
Excuse me?
Are you shaking your head to say no? I don't know how to interpret the answer.
I'm sorry, I didn't realize I was shaking my head.
Okay.
One second.
I thought he was actually answering a question.
Move to strike. The rules are well known to every lawyer who practices in the state of Florida, that it's clear that a nod of the head or a shake of the head is not understood by the record. So therefore, Mr. Epstein clearly was not responding to one of your questions, and you know that, Mr. Edwards.
This is on video, Mike.
Nonetheless, you know the rules. Nonetheless, if we have a question on the table, would you please repeat it so I can recall it and so Mr. Epstein can endeavor to answer it?
Sure, and if it was only a court reporter, I would agree, but the jury's going to see a video, and everybody knows commonly, if somebody shakes their head, they're saying no. If that was the answer, I wanted to give them a chance to elaborate on it. That's it. Isn't it true that when underage females would come to your house, you would engage in sexual activity with them and then pay them?
Same objections.
Utilizing this method of using underage minors to bring you other underage minors, you were able to engage in sex with hundreds of underage minor females. Is that true?
Form, argumentative, harassing, calls for speculation.
Since, Mr. Edwards, your firm has been described as a criminal enterprise by the U.S. Attorney, and as part of the largest fraud in South Florida's history, and as part of the fraud, fabricating malicious cases of sexual harassment and other cases of sexual nature against people like me and others, though I'd like to answer that question today, my attorneys have advised me I must assert my Sixth Amendment, 14th Amendment, and Fifth Amendment rights of the U.S. Constitution.
And Edwards also seems to be becoming increasingly frustrated with Epstein's long-winded, repeated answers to his questions.
To keep track of all of these underage minors, you stored their names and telephone numbers in your home computer, isn't that correct?
Form, argumentative, speculation.
Again? Sorry.
Are you going to answer the question or just read? If you are going to answer the question, of course, I'll keep reading it as many times.
Wait 1 second. The witness is attempting to answer your question. He asked you to repeat the question.
He is?
He asked you to repeat the question.
And I don't mind going through that, Mike, because I do want answers. But if I'm going to repeat the question multiple times and still get the same answer, we're just wasting time. I'm just trying to stop us from wasting time repeating questions if I'm getting the same non-responsive answer.
I understand your intention here.
Yeah.
However, these questions are similar in nature, if not identical, to various questions that you've asked in other cases. So you coming here today is of no surprise that Mr. Epstein is required to invoke his 5th, 6th, and 14th Amendment rights underneath the United States Constitution.
I understand that.
If you came here today thinking that you were going to pull a rabbit out of the hat and get, waive Mr. Epstein was going to waive his 5th, 6th, and 14th Amendment rights to the United States Constitution, at least not today. That will not be occurring.
And when Edwards asked Epstein to tell him about his recent sex crimes convictions, Epstein kind of becomes a little stubborn on that.
In June of 2008, you pled guilty to 2 felonies. Is that correct?
Same objection.
Yes.
And what were those felonies that you pled guilty to?
Solicitation of prostitutes, not underage prostitutes, but simply prostitutes. Solicitation of prostitutes, and one count of procuring a minor for underage sex.
And you've taken the fifth as to questions related to many of these underage minors, but the underage minors that were the victims in the cases where you pled guilty were, was that one of them?
Form mischaracterizes the witness's testimony, causes for a legal conclusion.
Again?
What was the name of any of the underage minors that were the subject of the criminal charges to which you pled guilty?
I don't know.
So tell me about those charges. What was the allegations of those charges?
Form.
Solicitation of prostitution.
Okay.
Not underage prostitution, prostitution.
Were the victims or the prostitutes, as you would say, were they minors?
Form.
I pled guilty to solicitation of prostitution.
Okay, so tell me what those cases were about. What happened?
I
Form
have no
again.
more. I can't tell you any more than that.
You don't know what you pled guilty to?
I just
I'm
told
going
you.
to object to form. That's asked and answered.
Do you know what you pled guilty to? The facts.
Solicitation of prostitution.
I understand that's the charge. What were the underlying facts?
Sorry.
What'd you do? Did you pull up in a car, talk to the person? Did they come over to your house? How'd you get them? Those kind of things. Tell the jury what were the underlying facts about the charge that you pled guilty to.
Form. Move to strike.
I don't know.
You don't know what you pled guilty to.
I pled guilty to solicitation of prostitution. Oh, not underage prostitution, but prostitution.
Okay. My understanding from reading the court file is that one of those females was. Do you know who that is?
I intend to respond to all relevant questions to this lawsuit.
Do you have any remorse for your actions against these victims that led to your plea of guilty?
Form. Argumentative.
I pled guilty to solicitation of prostitution. Not underage prostitution, simply prostitution.
Are you saying now that the subjects of that, which we're calling victims, were not underage when you engaged in sex with them?
Form. Argumentative. Speculation. And assumes facts not in evidence, as well as mischaracterizes the witness's testimony.
I pled guilty to solicitation of prostitution. Not underage prostitution, solicitation of prostitution.
I was of the impression that you pled guilty to a second-degree felony, that being procuring a minor for the purposes of prostitution.
That's correct.
Okay, so a minor is somebody under the age of 18, and I'm asking for the guilty plea related to that count. Are you at all remorseful for your interactions with that minor?
Same objections.
What minor?
The charge is procuring a minor. You tell me, who was that minor?
I don't know.
You were never told during your during the state attorney's prosecution of you who this person was?
No.
Why did you plead guilty to a felony charge that resulted in you going to jail, without even knowing who the victim was?
Form. That question calls for attorney-client information, and therefore I'm going to instruct you.
If it has something to do with any conversations with your attorney, I don't want to know. I'm just going off of the plea colloquy between you and the judge, where you understood the charges and you've been advised and apprised of the charges, and you still willfully pled guilty to the charges. So I'm taking now that you're saying you don't even know what those charges were about.
What was the question? I don't know the question on the table now.
Who is the minor?
I don't know.
And you were never told the name or initials of that minor victim by the state attorney's office or the prosecutor?
Not that I recall.
Well, just so that the jury understands, this method of paying underage minor females to bring you other underage minor females for sex is something that you do in New York, in New Mexico, in Florida, and everywhere. It's not just West Palm Beach, isn't that right?
Again, form, it's compound. Again, it assumes facts, not in evidence. It's argumentative, it's harassing. And moreover, we've already been down this road before in separate related questions that have already been asked and answered.
So Edwards accused Epstein of using and abusing his client as part of a scheme to attract as many teenage girls as possible to his property, where he would give them money in return for massages and sexual favors.
Did the computers that were removed from your home just prior to the execution of the search warrant contain the complete list of underage minor females with whom you engaged in sexual activity? Isn't it true that you and operated as an organized criminal enterprise designed to sexually exploit minors?
Objection.
And as part of that organization, you developed code terms such as work or massage as opposed to engage in sex with minors. Is that true? Isn't it true, Mr. Epstein, that the only thing that you cared about was accessing as many underage females as possible for the purposes of sex?
It's argumentative, speculation. It's harassing.
It's not. What's the question?
And it assumes facts, not in evidence.
Isn't it true that the only thing that you cared about when you were interacting with these underage females in a sexual manner was or your own personal gratification?
Form, same exact objections.
Though I'd like to answer that question, and to the ladies and gentlemen of the jury, I'd very much like to answer that question. However, today, my attorneys have advised me I must assert my rights under the 14th, 6th, and 5th Amendments of the U.S. Constitution.
Any underage minor female that you engaged in sexual activity with and that has now pursued a lawsuit against you, isn't it true that you've spent a lot of money and a lot of resources investigating them in an effort to intimidate them and hopefully make them go away?
Same objections.
I believe your client's testimony changed dramatically when she joined up with you and your law firm accused of fraud. When she decided to change her testimony, at least from what these statements said, both to the police and to the FBI, and decided to seek money. However, anything above that or beyond that, I'm going to have to, in fact, assert my 5th Amendment, 6th Amendment, and 14th Amendment rights as directed by my competent counsel. Unfortunately, they have told me that if I don't, I risk losing their representation.
All right, I'm going to give you a chance here since you keep bringing up her statement to the FBI as opposed to her sworn testimony for 13 hours under oath in this case. Are you saying that the sworn testimony to the FBI was in fact the truth?
What I'm saying is it seems her testimony has changed dramatically after she joined your firm. That's all.
Irrespective of her testimony. You've read her testimony and you to the FBI. You've watched her deposition when it was being taken. Which
you're making assumptions. I'm sorry. So
just go ahead and let him finish the question.
Sorry, my fault.
And then I'll object, and then you'll respond.
Which are you saying is the truthful testimony? Her statement to the FBI or the videotape deposition that you watched?
I'm going to object for him.
What I've said, and I think I'll repeat myself, is that until she joined your firm and started to seek money, her testimony was different. That's my understanding. Sorry.
Are you denying any sexual involvement with this time?
Form.
I'd like to answer that question. I'd like to answer as most of your questions here today. However, my attorneys have advised me that I must assert my rights under the 6th Amendment, 14th Amendment and 5th Amendment, no matter how much I'd like to answer that question, or, excuse me, potentially risk losing my counsel.
Isn't your game plan with all of these civil lawsuits that have been filed against you to spend as much money as you can to investigate and harass these young women into hopefully dropping the lawsuits against you?
Objection, irrelevance, move to strike. So it's argumentative, it's harassing.
I'd like to answer that question. I think you know the answer to that question.
Yes.
Now, here they refer to a woman whose name we've chosen to keep anonymous, but she was accused of being one of the teens that helped find other girls for Epstein.
Is it your feeling that because you are wealthy and these children are poor, that you are entitled to sexually abuse them?
Argumentative.
And speaking about these children, including
Argumentative, speculative, it's compound, it's vague, it assumes facts not evident.
Yes, and in keeping with your firm's propensity to file fallacious, manufactured, sexually charged cases based on nothing but thin air, accused by the U.S. Attorney of the largest fraud in South Florida's history by manufacturing sexual cases, I would like to answer each and every one of your questions, including why I sued you. But today I'm not going to be able to.
Please tell the jury, what is your defense of the claims being asserted against you in this lawsuit by
I'm going to object. It calls for a legal conclusion.
You have to. What are the claims, sir? Since you're representing, could you tell me what the claims are?
Yeah, we've gone through it. She went to your house when she was 13, 14, 15, 16 years old.
Is that a claim?
She was in your bedroom. You instructed her to get naked. You coerced her into recruiting other underage minor females, roughly 50 or so more. These are all claims that have amounted to various counts: coercion into prostitution, intentional infliction of emotional distress, battery, committing various crimes against her. What are your defenses to that? I mean, normal defenses are, I didn't do it. I did it, but it didn't hurt her. And we're trying to understand, so we understand how to provide this case to the jury. What are your defenses to these allegations?
I'm going to object to this line of questioning. It's compound. As worded, it could call for the disclosure of attorney-client information as well as work product. And I believe in this particular case, there is a document filed answering affirmative defenses, and those affirmative defenses are set forth, and the document there speaks for itself.
Okay. Respond.
The document speaks for itself.
And as the deposition came to an end, Epstein insinuated that despite refusing to answer almost every question that was asked, he was innocent.
Since you are a lawyer, I'm sure you're aware the Supreme Court has said that the Fifth Amendment is used more often to protect innocent people. And up it's today, the Vice Counsel taken that right.
Okay. I have no questions.
No further questions.
Going off the video record at 3:52 p.m.
Okay, so what happens? Well, LM and Epstein, they actually settled out of court. The case apparently was dismissed. It's not clear exactly how much Epstein might have paid to settle, but I will tell you this much. Epstein, at one point in time, actually apologized to Edwards in court, saying, quote, "While Mr. Edwards was representing clients against me, I filed a lawsuit against him in which I made allegations about him that the evidence conclusively proves were absolutely false. The truth was that his aggressive investigation and litigation style was highly effective and therefore troublesome for me." Now, we also found the filing that after Epstein's death, his co-executors had filed a voluntary motion to dismiss the case against Scott Rothstein as well. That's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. You can also check us out on NBC's Peacock as well. If you want to follow me, X, Instagram, my News Nation show, Jesse Weber Live, Monday through Friday, 11 p.m. Eastern. I'll see you next time, everybody.